Good morning. This is Tony McDowell. I'm the Executive Director for the Opioid Abatement Authority, and it's my pleasure to welcome you to another installment, the September 26th installment of the Virginia Opioid Abatement Authority's Abatement Academy, which is a series of free online live presentations designed to help communities identify strategies for addressing the opioid crisis at your local level. This series features speakers who voluntarily contribute their time to share examples of best practices for opioid abatement and remediation strategies, as well as technical assistance towards applying for OAA grants. Before we jump into this topic for today, there are a couple of housekeeping items to review. First, if you have any questions during the course of the presentation, please feel free to type them into the Q&A feature. The chat feature is not enabled because of the type of webinar it is under Zoom, but you can type your questions into Q&A, and we'll either address those as they pop up or at the end of the prepared comments. Also, this webinar is being recorded. That way we can share it after the fact with people that weren't able to attend live. And both the recording and the presentation will be posted on our website. Today's Thursday. We'll usually takes a couple of days to get it cleaned up and posted. So by Monday of next week, you should be able to see it. Okay, so with that, we will go ahead and jump in. So right off the bat, we are doing a two-part presentation. Part one is today. This is preparing your Opioid Abatement Authority grant application. We're going to be talking about the types of grants, projects that are eligible. We'll talk about the amount of funds that are available and how to make your application more competitive. So what this is not today is about how to go about the process of completing the actual forms. That will be the subject of the next Abatement Academy that will be held on October 10th at 10 a.m. And you can sign up for that on our website. And in fact, on October 10th, we will not only be explaining how to physically fill out the application and the logistical details of that, but we're also going to be introducing our new online grants portal. So those of you who've applied for a grant in the past know that during the last two cycles, everything was done on paper or in Excel spreadsheets. We now have, as of Tuesday next week on October 1st, we will be launching our professionally developed web-based portal, which is the difference is like doing your taxes on the forms versus having TurboTax guide you through the process is sort of the way I look at it. So hopefully this will make the application process a little bit easier and allow you to more easily track your past information, the finances that are available to you, and all of the related details that you need to manage your grants. Okay, so let's jump in on some background information. I know that some of the folks that are on the call have probably seen some of this already. Hopefully it's a good review and not too much of the same information, while at the same time providing the background that folks that are new to the topic haven't already heard. So when we talk about opioid settlements that are covered by the Opioid Abatement Authority and by Virginia's Opioid Abatement Fund, we're talking about a group of settlements that have been negotiated out of one multi-district litigation courthouse, federal courthouse in the Northern District of Ohio. These started out as individual lawsuits filed by states, by various cities, counties. You know, some states have townships and parishes and other types of local governments. And by 2017, there were over 3,000 such lawsuits that have been filed, and they were all combined into one multi-district litigation case that's been heard at the courthouse that's pictured on the screen by one judge who's overseen all of the negotiations. And so unlike the tobacco settlement, there is not one master settlement agreement here. Each one of the defendants has had the opportunity to negotiate their own settlement with the various plaintiffs and then offer that settlement to each state. And each state has the opportunity to decide whether or not to accept that settlement. And so what did Virginia do? Virginia sought to get all 133 of our cities and counties to agree to release any litigation that they had filed against these companies, or to not file cases in the future, and instead to join into the settlement that was being offered to the state based on the national agreement. And so the Attorney General negotiated with our 133 cities and counties about how the funds coming to Virginia would be shared between the state, the cities, and the counties. And that culminated in an agreement that we refer to as the Statewide Allocation Memorandum of Understanding, or the MOU. And this MOU, which was again negotiated by the Attorney General working with local governments, was negotiated with input from a number of interest groups across the state, and it established the formulas that dictate how the money is going to be shared when it comes in. It also set up the Opioid Abatement Authority and described its duties and responsibilities, and it describes in detail the allowable uses and then state requirements about any of the funds that are distributed by the Opioid Abatement Authority to cities and counties in Virginia. And once this agreement was agreed to by all 133 cities and counties, it was then essentially put into code by the General Assembly in 2021. And each time that a settlement comes forward to Virginia, a Virginia court has to attach this MOU to the state level settlement. And so the point to all this is that there are multiple legal documents that establish the framework for how opioid settlement funds are distributed in Virginia. So a little bit of details about that. If you'd like to see the actual allocation agreement, this is a screenshot from our website, and we've included the address here on the screen. If you want to take a look at the allocation agreement, you can see the actual agreement with the signatures and everything right there on our website. Okay, so as I mentioned, unlike the tobacco settlement, with the opioid settlements, we're talking about more than 24 different companies that Virginia has litigated against. Some of the major companies that are involved in this litigation are shown on this screen. Each one of these companies has negotiated its own settlement or bankruptcy, with the exception of 3 pharmaceutical distributors. We call these the distributors, and they include McKesson, AmerisourceBergen, and Cardinal Health. Those 3 companies negotiated together in one settlement that describes all 3 companies' participation. Those settlements actually started, the McKesson, AmerisourceBergen, and Cardinal Health, the distributor settlement actually began making payments in 2022, as well as Janssen, which was a pharmaceutical arm of Johnson & Johnson. Of the other companies that are listed on the screen, almost all of these have begun making payments. The ones that are still pending include Kroger, which is a settlement that's in final negotiations. Not even negotiations, it's really more about getting all the documents signed. And then Mallinckrodt was a bankruptcy that has paid out. They're finished making their payments. Endo is in bankruptcy. Purdue is in bankruptcy. But the key here to all of this is that the total amount that we're expected to see in the state of Virginia from all of these companies over the life of the settlements is just about $1 billion, of which 55% comes to the Opioid Abatement Authority. And we'll talk about those percentages again here in just a moment. So what do the amounts from each company look like, and the terms of payments? I'm not going to get into a huge amount of detail on this, but you can see on the pie chart that those 3 distributors represent the largest share coming to Virginia, and then Janssen, Walgreens, CVS are all major participants. In this particular projection, we've shown Purdue at 0. We were expecting originally about $100 million total to come to Virginia from Purdue, of which about $555 million would come to the Opioid Abatement Authority. We've netted that out to 0 for now because the Supreme Court vacated the lower court's bankruptcy decision on Purdue, and so that's back in mediation and could wind up in litigation again. And so for the time being, we've zeroed that out because we just don't know how much is going to be coming from Purdue. The good news is that the uncertainty around Purdue has not affected any of the grants that we've awarded so far, nor does it affect the budget that we have for the next several years. And so we can continue to move forward with those obligations. A little bit about the cash flow from these grants. The line on this chart represents the expected payments coming to the Opioid Abatement Authority over the life of these payments, over the life of these settlements. The bars represent the budgeted amount of awards that we plan to give out each year. And so what you can see is that in fiscal year 23 and 24, we received more money in settlements than we paid out. Part of that is because everything we're doing is brand new. The other part was intentional. We didn't want to have a lot of volatility in the awards. We wanted to have some predictability and some sustainability in the awards that are going out. And so this relatively steady level of funding that you see for the first several years was done by our board with intention. A key takeaway here is that we don't have funding in perpetuity. A number of the grant applications we've received have asked for increasing amounts each year. And that's really kind of going the wrong direction because the amount of funding we have available to award each year is either, at best it's level, and in reality it goes down over time. So we're going to be talking in a minute about why it's important for your programs to be projecting sustainability going into the future. So how can these settlement funds be used? Well, it varies because each one of the settlements has the opportunity to be structured differently. So the allowable uses for the most part don't change. Those are all listed in a standard document that's called Exhibit E. It's the same exhibit or attachment to all of the nationally negotiated opioid settlements. What's different is some of the rules about the way the money can be used. And what changes is the percentage that has to be used on abatement. Some of these settlements, every penny has to be used on abatements. Others provide some wiggle room with all kinds of disclaimers attached. Some of them address supplanting, which is when you replace existing funding with funding that you're getting from the settlement. Some of them don't address it, and which leaves it kind of a point of potential future debate and litigation. And the reporting requirements vary. Some of these settlements don't require any reporting requirements by the settling company. Others have very specific requirements to the settling company. And so, this gets into a very legal area here. If as a locality, you're interested in knowing the exact rules around any one of the settlements, you really will have to speak with your legal counsel to get those details. However, as I said, Exhibit E is the standard list of approved strategies for the use of the funds in terms of abatement-related uses. And you can find this exhibit, again, going back to the screenshot of our website. If you follow this hyperlink, you can find Exhibit E on our website, and you can see it for yourself. But in general, it lists 9 core strategies. This was developed by a group of nationally selected experts on opioid prevention, treatment, recovery supports, essentially abatement purposes. And the uses fall under these 9 core strategies. And if you look at Exhibit E, there's a wide range of examples of these different types of strategies, but they include things like distributing naloxone, advocating for treatment, medication for opioid use disorder, special focus on pregnant and postpartum women with opioid use disorder, expanding treatment for neonatal abstinence syndrome, recovery supports, treatment and diversion for people who are incarcerated, prevention and education programs, syringe service and harm reduction programs, and then a variety of data collection and research strategies. So it's a pretty broad umbrella. And sometimes we get the question about, what about substances aside from opioids? Really, the way the state law is written and what you'll find in Exhibit E is that as long as there's a nexus to opioid use, you'll be in good shape, because it's for opioid use disorder and co-occurring behavioral health and co-occurring addiction. And for the most part, if the efforts that you're interested in promoting are addressed towards people that are high risk of developing opioid use disorder, then that really is an umbrella that includes people with other types of behavioral health and mental illness. And so, yeah, I think the goal here is that we don't want to use these funds to fill potholes and to plug budgets, to plug budget holes, but really to help people that are struggling with addiction. Okay, so let's talk a little bit about how the money is distributed once it comes to Virginia. And so the main thing I want to focus on first is this pie chart. So every dollar that comes to Virginia from an opioid settlement is divided three ways as represented on this pie chart. And I'll just start with the share that goes directly to the Commonwealth. And this is referred to, let me back up. 15% of any settlement goes to the Commonwealth's Opioid Abatement and Remediation Fund. This is a special fund that has been set up in the state treasury pursuant to the code section that's listed on your screen that basically says these funds can only be used for approved opioid abatement remediation purposes. So it's not in the state's general fund, it's in a special fund. The Opioid Abatement Authority does not control these funds. These funds are appropriated through the normal state budget process. So when the governor develops a budget and proposes it to the General Assembly, the governor can call on budgeted uses for funds from the core fund. Members of the General Assembly then do their normal thing that they do each year with the budget, where they review, they debate, they can put in budget amendments, and ultimately, when the budget is adopted, it will identify uses from the core fund for opioid abatement remediation purposes. The OAA is responsible for tracking those expenditures and tracking the outcomes. 30% of every settlement goes into a pot that's shared between the 133 cities and counties in Virginia. And I'll talk a little bit about how that sharing occurs in just a moment. The remaining 55% comes to the Opioid Abatement Authority. And technically, it's deposited into a fund that's established under the code that's called the Opioid Abatement Fund. And the Opioid Abatement Authority's board makes distributions from this fund to cities, counties, and state agencies. We're required to follow a certain distribution plan that we've shown on this side of the chart. And I'm going to explain each of these in more detail in just a moment. But let's go back to a second for this blue slice of the pie, the 30% that's set aside for cities and counties. How do we know how much is set aside for each city and county? Well, it's based on a measure that the cities and counties came up with and agreed to in the MOU. And it's based on a measure of harm per capita. And so I think the effort was to balance both the number of people that live in a community as well as the level of harm that occurred specifically to that community. And this formula that was developed by researchers at UVA resulted in a measure that all cities and counties agreed to in the MOU. And just as an example of how it works, we've chosen sort of two different ends of the state. Fairfax County population is about 13.1% of the state's population, but because the amount of opioid harm in Fairfax County was relatively less than it was in other parts of the state, they will receive 8.67% of the 30%, rather than if you were doing it just based on per capita. Conversely, if you look at Wise County, Virginia, which is close to the epicenter of the opioid crisis in Virginia, even though that population of Wise County is less than half of 1% of the state, they receive 1.8% of the allocation. So that means that Wise County receives 1.76% of 30% of this direct share. And those funds go directly to Wise County. They don't come through the Opioid Abatement Authority. And similarly, Fairfax County gets 8.7% of the 30% that goes directly to Fairfax County. And each city, each county in the Commonwealth has a share that's identified to go directly to them. All right, let's change gears a little bit and talk about the funds that come to the Opioid Abatement Authority and how we're required to distribute those funds. Well, similar to that 30% that's set aside for cities and counties, 15% of the OAA's fund, 15% each year, is set aside for cities and counties. And then we assign to each city and each county a share of that 15%. So going back to our prior example, Wise County gets 1.67% of that 15%. Fairfax County gets 8.7% of that 15%, and so forth. But instead of that money being automatically sent to the cities and counties, it's what we hold on to. We earmark those amounts of money for each city and each county. We know exactly how much each city and each county is supposed to receive, and we set that up basically an account under the name of that city or that county. That money basically belongs to that city or that county. But in order to receive it, they have to apply to the OAA for an individual grant. And this is a pass-fail grant application. Either it meets our criteria or it doesn't. If it meets the criteria, then we release the money to the city or the county. So it's not competitive. It just has to meet Virginia's law, which is more strict than what the settlement requirements require. So this is an important distinction because, as I mentioned, flipping back to our chart here, these funds go directly to the cities and counties. And so the use of these funds is dictated by the settlement agreements, not by state law under the Opioid Abatement Authority. The money that cities and counties get from the OAA have to meet those settlement requirements, but they also have to meet state law. So you have to submit an application, you have to agree to our terms and conditions, and we accept applications from cities and counties from October 1st through April 1st of each year. Okay, a little bit about what our separate, more strict requirements are. First of all, every penny has to be spent on approved opioid abatement purposes. You can't use these funds for anything other than opioid abatement. You can't reimburse yourself for previous year's costs, and you can't supplant. There's no indirect charges allowed. Indirect charges is where you say, well, this is going to take some time from our city attorney or county attorney. It's going to take some time from our budget staff. So we want to claim 3% off the top. That's sort of an arbitrary number that's allowed with federal grants, but it's not allowed with Opioid Abatement Authority grants. You are allowed to charge for direct administrative expenses, but not for sort of off the top type of arbitrary percentages. And then the final requirement is that recipients of Opioid Abatement Authority grants have to report back to us on an annual basis how they spent the money and what the results were. So this is where things get a little bit interesting. We want to incentivize cities and counties to follow our rules, the OAA's rules, with the money that we distribute to them, but also the money that they get directly from the settlements. And so the deal we offer you, the incentive is that if you will treat these funds according to the same rules that we require for the funds that we distribute to cities and counties, then we will increase the amount that we're holding for you by 25%. We pay for that out of an unrestricted bucket of the Opioid Abatement Authority's fund. So it's not coming out of any other fund that you would otherwise be drawing money from. Okay, let's talk a little bit about how you figure out how much money you have available from all of this. And so if you look on the OAA's website, this is the same page that I've been referring to in the other screenshots. We have a lookup tool that we periodically update as numbers change. That's an Excel file. And you click on this and it downloads it, and you can choose from a drop-down menu which city or which county you're interested in learning about. This is a little bit of an older screenshot. This is from April of this year, but the layout is the same. And what we've done is we've shown by fiscal year, so the fiscal years that are behind us, these numbers are actuals. The fiscal years in the future are estimates that we believe based on the latest information we have. The green columns show the amount that Powhatan County is going to be receiving directly from the settling companies, okay? So these are funds that do not come to the OAA, and for that reason, Powhatan or any other county doesn't have to apply to the OAA to receive these funds. These funds come to the county or to the city as the payments get made through the court-appointed settlement administrator. Now, what we've done here is we've listed in this column when a locality has requested to use a portion of these funds as a match for an OAA grant. And we'll talk more about that in just a moment. But this is where you can see how much is expected to be paid each year to each jurisdiction. Under the blue column, you can see how much the OAA is reserving for each city or county based on these non-competitive individual grants that you're eligible to apply and receive from the OAA. And then if you're willing to follow our gold standard incentive that I just described, this is how much that 25% incentive is each year. And so this lookup tool gives you an estimate of how much money is available for you to apply, for you to receive or to apply for non-competitively each year. We also have competitive grants that I'll talk about next. Okay, so moving into the competitive grants. The law requires that we offer 35% of our fund go to provide funding for cooperative partnerships. Now, cooperative partnership is when at least two state subdivisions, which is a city or a county, at least two cities and or counties come together and agree to cooperate on the same project. One of them has to act as a fiscal agent. Now, you can have 8 cities or counties, you can have 4, you can have 3, but you have to have at least 2. And the fiscal agent and at least one other of the jurisdictions have to be in the same DBHDS region. That's part of the state code. But once they come together and they form an agreement, then they can jointly apply for a cooperative partnership project to the OAA. And because this represents 35% of our budget, these are significant amounts of funds that are available. You submit one application, and all the cities and counties that are partnering on it sign off. The fiscal agent has the responsibility of completing the overall application. Now, how do we decide which ones of these projects to fund because they're cooperative or because they're competitive? I'll explain that in just a moment. The application period is the same as it is for individual applications. So we accept applications from October 1st through April 1st of each year. So we're a week away, less than a week away from opening up applications for these grants. All right, so how do we prioritize cooperative partnership projects? We're required by law to prioritize the following items when we're looking at these applications. The first is we have to provide what the law calls equitable distribution between the 5 DBHDS regions. What that means is that if your locality is in Region 3, which is the far western part of the state, you're competing with other cooperative partnerships within that region. You're not competing against cooperative partnerships that are proposed in Northern Virginia or in Hampton Roads. You're only competing for funds within your DBHDS region. And each of the 5 regions has, the OAA has created a budget for each one of those 5 regions that's essentially very similar amount of money. There are some variations in the amount based on that same measure of harm that we already described. So we look at an opioid-related harm per capita in each one of those regions to determine what the regional budget is. And so for the most part, the budgets range between $3 and $4 million for each one of the 5 DBHDS regions. So that's what you're competing for. You're competing for somewhere between $3 and $4 million against other potential cooperative partnerships in your region. We also prioritize economically disadvantaged communities. We provide priority to projects that where the partners that are involved have a proven record of success, and programs that are both evidence-based and programs that have a record of generating good results. And last, probably most challenging, is that we're required by law to prioritize projects that come with a local cash match. And the more the match, the higher the amount of the match, the more priority we're required to assign to the proposed project. And so just a word about what that local match is. It has to be cash. It can't be in-kind services. It can't be the value of your existing staff that are going to be working on projects. It can't be real estate that you have that you're willing to put towards the project. It can't be any kind of in-kind service. It has to be actual cash. Now, it can be from locality's general fund. It can be cash that a private or nonprofit organization is putting towards the project on behalf of the applicant cities and counties. It can be other forms of revenue that you have, and it can include money from your direct distribution. The money that's coming to you directly from the settling companies can be used as your cash match. You can also use the money that we're holding for each locality in their individual account that can be used as the cash match. So any combination of a cash source is an allowable use or is an allowable example of a cash match. Okay, so those are the two main categories of grants that we offer for cities and counties: the individual awards, with their non-competitive, and the cooperative partnership awards that are competitive. Changing gears now, just so everyone on the call is aware, we also provide funding to state agencies. That's 15% of our annual budget. These are competitive, and they're not grants, they're agreements that we enter into with state agencies based on a request for proposal or RFP process that we engage in the spring, early summer of each year. We review these proposals, that we apply the same priorities that I just described to you. And at the end of the day, we bring forward MOUs with the various state agencies that become funding agreements between the OAA and the state agency. So if you're a state agency or you think you might be a state agency and you're interested in more information, we offer separate training programs for this type of grant. But essentially, you have to be an agency of the Commonwealth, which can include an executive branch agency, a legislative branch agency, an independent authority. It includes Virginia public universities, any entity of the state that's established within the code or receives direct funding from in the General Assembly's budget. If you're not sure whether you're an agency, a state agency eligible to apply, feel free to reach out to the OAA and we can discuss that. And finally, the last part of our budget is the unrestricted pot. This is where the Opioid Abatement Authority's board has a certain amount of discretion to spend more money in these previously identified areas than what's listed. So as an example, if the board really likes the cooperative partnership applications that it's received and it wants to assign more than 35% to fund those, then they have the ability to do that and to pay for the difference out of the unrestricted fund. Similar with the individual awards or with state agency awards. They also have the ability to develop special one-time grants. So some of you may have heard about planning grants that we offered last year. Those were paid for out of the unrestricted budget. They were special one-time grant opportunities. And it's also where we pay for the gold standard incentive. And all of our operational expenses as an organization have to be paid for out of the unrestricted fund. All right, so where are Virginia local governments making investments with opioid settlement dollars? We've listed some examples of programs where we see most of the applications that are coming to us fall into these categories. So prevention programs for kids, so education, prevention programs. We do require that these programs be evidence-based rather than something that somebody just came up with on a whim. So any kind of education prevention program is going to qualify. Naloxone distribution programs, including leave behind programs. We're seeing public safety efforts, EMS, law enforcement, leave naloxone behind at appropriate scenes. Mobile treatment programs, behavioral health crisis programs, as long as there's a connection to opioid use disorder. Crisis receiving centers, recovery courts, jail diversion programs, jail-based treatment and reentry planning. Foster care prevention. This is a key topic in Virginia. So we're talking about things like kinship navigation programs, kinship support, anything that can prevent kids from sort of falling through the cracks in the foster care program, because we know that's a significant risk factor for developing substance use disorder and opioid use disorder. And then a wide variety of supports for people that are in recovery. And that can include recovery-related housing, transportation, job training, job pipelines, and so forth. Okay, let's talk a little bit about some trends that we're seeing with the applications that come in, some of the challenges that we tend to work with our applicants on, and advice that we have for either new or returning grant applicants. So first, right off the bat, one of the trends we've seen is that cities and counties are not applying for their individual distribution grants. There's a lot of focus on the competitive cooperative partnerships. Um, and obviously there have been some individual distribution grants applied for, but most cities and counties have not come to us with specifically with a grant for an individual distribution, other than using it as a local match for a competitive grant. As a reminder, our board has established a 5-year use it or lose it policy, which means 5 years from when the funds were deposited into your account, those funds can be taken back out of the account that's designated for that locality and put back into the main fund to be shared between other localities. And so this would only apply for the funds that have been sitting in your account for 5 years. But we're coming up on our third round of applications, so it's important for cities and counties to recognize that there is sort of a statute of limitation on using these funds as they come into your account. Another trend is that sometimes the applications we receive don't really have very realistic implementation timeframes. So if you're planning to acquire property, to hire staff, to enter into partnerships, take those into an account on your timeline, because otherwise we wind up providing funding. As an example, we might provide funding for a full year of a project, but then the project takes 6 months to get up and running. Then you don't spend all the money that we've awarded, and then you have to apply for a carryover. And it would just be better for everyone involved to put a little bit of focus on the implementation timeframe. Sustainability is frequently a challenge with the applications we receive, because we really need to know, particularly on the competitive applications, we have a process where we can work with you for multiple years, but we need to see what the long-term sustainability is of this program. We can't provide permanent, ongoing funding in perpetuity for these grants. And so is the plan to sunset the program after a couple of years? Is it to begin to bring in some additional funding from local sources? Is it to get clients enrolled in Medicaid? What is the long-term plan? We'd really like to be able to see that. Sometimes applications come in and it's not really clear who the partners and subcontractors are going to be. So we kind of need to know that in the process as we're evaluating these applications. So are you working with your community services board? Are you working with a nonprofit? Are you working with private providers? And if so, who are those organizations? And one thing to keep in mind is that receiving a grant from the Opioid Abatement Authority does not exempt a city or county from following existing procurement laws and policies, both the state procurement law and local procurement policies. So if you're going to work with a nonprofit or with a private provider, and the amount of money that you want to give to them from your OAA grant triggers a procurement process, you still have to go through that procurement process. We don't oversee that procurement process, but understand that the cities and counties are already required by longstanding existing state law to follow state procurement and local procurement policy when working with grant subrecipients. It's clear to us when a grant has benefited from substantial advanced planning. And the programs that come to us that are well planned out, they tend to have more partners, they tend to have letters of support, and they tend to sell themselves better. And so when you're talking about projects being competitive, the more time you've spent developing the partnership, the more time that you've spent building out the program, the more likely those programs are to sell themselves to our board. Another challenge that we see is sometimes some outstanding conceptual plans, the budget that comes with it or the math that's behind it doesn't exactly add up. And so we strongly recommend that applicants or authors of grant applications work with your budget department and get help making sure that there's a budget plan that accompanies the programmatic plan when the grant is submitted. We do require performance measures as well as implementation timelines for all of our grants. And if it's a brand new program, we'll work with you to right size those performance measures as the program rolls out. But we've seen some grants where the performance measures were kind of pencil whipped, to be honest with you. And it's really best if you can spend some time thinking about what the performance measures really need to be and what's possible and what's doable. And the quality of the performance measures is an important part of our review on competitive projects. And just again, I'm sort of overstating the point here, but we frequently receive applications that are right at the deadline, that are incomplete and they have problems, but like no one called us ahead of time to discuss it. And folks, this is all we do. This is the only thing we do year round is work on these grants. So please give us a call and or email us. Let us help you complete your application so that when it gets turned in by the deadline, that it's complete and it's ready to be considered. Okay, just some general advice for applicants. Um, we really recommend that you start by collecting feedback at the community level and involve your stakeholders. Define what the problem is within the community, and then look for the solutions that can fill in those gaps. We frequently will get questions of, hey, can you send us a list of things that we can use the money for? And we're happy to do that, but our advice is to take a look at what needs exist in the community, what services exist, and where are the gaps. And from there, begin to look at solutions rather than picking from, like a menu of things that we can provide you. Again, start early in the process and submit your application ahead of the deadline. Don't hesitate to contact the OAA to talk about your idea and to get feedback. We'll help you. We will help you write your application. And then when it comes to the funding piece, it really helps if you have both a short-term and a long-term plan, a budget that takes into account all of the money that you are likely to receive, both from the direct payments as well as the funding that you're eligible to receive from the OAA, and plan all of that out. Because otherwise, if you just do it 1 year at a time and one project at a time, it kind of takes on a little bit of a whack-a-mole type of approach. And it's easy to lose track of where you've committed various different pots of money. So we recently, on September 12th, we asked Miss Virginia Lowell, who's the Director of Finance for the City of Newport News, to share with our stakeholders what she had done, she and others, for the City of Newport News to come up with a multi-year strategy for the use of their funds in order to meet the City of Newport News opioid abatement goals. And so that presentation is available on our website. You can watch the video, you can look at her presentation, and we even included financial guidance that's been provided by the Auditor of Public Accounts. And the link for all of that is provided on this slide under OAA's Abatement Academy. But I stole one of the slides from our presentation, but the takeaway point here is that Virginia anticipated, looks like when I copied it, I failed to bring over the column headings, but each one of these columns is a year. And so what they've done in Newport News is they've planned out for multiple years what their budget is going to be for their opioid abatement strategies. And then they've identified where the revenue is going to come from, both from their individual OAA funds, anything that they don't finish spending that they carry forward, their direct funds that they receive directly from the settlements, and any interest that they gain on their direct funds. And so you see they have an anticipated budget amount each year, and then they've listed out the expenses that they're going to be incurring for the various programs. And so all of this balances. It's going to be a work in progress. She'll tell you that they'll have to revise it each year, but like any budget, it's a plan. And this really helps us understand what the long-term plan is and work with the locality to ensure the sustainability of these projects. Getting close to wrapping up. Our competitive applications. So really what we're talking about is the cooperative partnerships. Each year we're seeing that they're becoming exponentially more competitive because everybody wants to get their hands a hold of these additional funds that are out there. Because we're required to prioritize applications with local matches, we really recommend that you consider beefing up that local match, the overall percentage of the local match, because this is really where you have the chance to make your project pop out from the crowd. And so the more that you can contribute from your other opioid funds or from other local revenues that you're able to put into the project, the more competitive it's going to be. People ask for a specific number. It's really up to you, but a project that comes in with a 10% match that is competing with a otherwise very similar competing project that's got a 50% match, the 50% match is more likely to get recommended for funding than the one with the 10% match. All other things being held similar. Again, articulate your plan for sustainability. Sometimes the statement we'll get is that, well, we'll figure it out in the future. And that's fair, it's honest, but the better the plan can be, the more detailed the plan is, the better it is for us to be able to explain to the OAA board that they take into account in their final decision. Bring in as many partners as you can from the community, because that strengthens the application. Be realistic and honest with your proposed performance measures and your implementation timeline, and ask your peers from other cities and counties to review what you're doing for feedback. So my goal was to try to wrap up all of this in 45 minutes, and we're at 46. And so this is the point of the presentation where I pause. I'll reiterate, as I said at the beginning, that we will be providing all of this, the recording and the presentation online. You will also, anyone who's registered for this webinar will receive an email with the information. So even if somebody was registered and they didn't attend, they'll still get the email. And with that, I will turn it over for Q&A. And we already have a couple of questions in the Q&A. I'll begin to address those. Stop sharing the screen. So the first one is, does bankruptcy change the amount that localities expect to receive? No, the bankruptcy amount determines the amount coming to Virginia. The amount going to localities is then based on the Virginia MOU and Virginia state law. Second question is, would you consider OAA funding for a recovery school, a Core 5 warm handoff and/or Core 7 prevention and education, or both? So I'm thinking this is for a recovery school, being something like Chesterfield County has a regional recovery high school, and those programs are considered allowable uses of opioid settlement funds. Now, the disclaimer here is that while I can tell you in general a recovery school sounds like an allowable use, we would have to look at the details to give you a final firm answer on it. But the general answer is yes, that does sound like an allowable use. Another question or comment is, would a promising practice be considered or just evidence-based? Well, we'd have to take a look at it. If there is some sort of evidence that the promising practice is yielding good results, then it could be considered as evidence-based. We, the OAA, also have a contract with the Wright Center at Virginia Commonwealth University to take a look at proposals to determine whether or not they meet an academic standard of being evidence-based. And so there are multiple ways for us to evaluate that. And then another question is, will the new system be able to provide our own performance measures, or will we still be restricted to the measures that were listed on the former Excel sheet? So the performance measures that we offer, a set of about 65 pre-identified performance measures that you pick from. You can do additional performance measures for your own reporting, for your own internal reporting, but the ones that you report back to us have to be from the data set that we put together. And there's a couple reasons for that. One is we want to be able to look statewide. And so we want to be able to take the data from each locality for a particular measure and load it into a statewide system so that we're comparing apples to apples statewide. In addition, we were trying to have measures that had a similar level of focus, so that even though we have large communities and small communities participating, that they all have the same types of performance measures in order to make these more standardized statewide. For what it's worth, the measures that we selected were drawn primarily from the Medicaid, Department of Medical Assistance Services, Medicaid performance measures. So we didn't like come up with those out of thin air.
Tony, could I add one more point to that?
Sure, Charlie, please jump in.
There will be so those pre-populated performance measures will still be there, and we'll be looking for you to hopefully select a few out of that. But there will be the option for you also to add other performance measures in the system. A feature we didn't have really built into that workbook if there's some things that help better or more fully tell the story of your project. So, but we are still looking at data aggregation and that type of thing. And but over time, we will probably revisit and solicit feedback on those performance measures probably in another year or two.
Great, thank you, Charlie. The next question is, do renewal cooperative applications compete with new cooperative applications? If yes, does a renewal application have a greater weight because previously approved? So this is a great question. So for our cooperative partnerships, it's the intention of our board to provide, once an award has been made, that's the intention of our board to offer renewals up to 4 times, which means that a renewal to the second year, a renewal to a third year, a renewal to a fourth year, and a renewal to a fifth year. It's contingent on a couple of things. It's contingent on funds being available for the OAA. And so what that means is that if your costs are going to go up, then we can't necessarily guarantee that we can increase that we can cover that increase in cost. If your budget called for revenues to be coming in future years and they're not available, then again, that doesn't necessarily mean that the OAA is going to be able to cover that shortfall for you. It's also contingent on the project being implemented in the way that you proposed, and that the performance measures continue to generate some progress towards what you proposed, and that the applicant remain compliant with all the terms and conditions. And then finally, that the settlements continue to pay in the way that they are projected. So all things being equal, we want to be able to renew those projects in the way that we described when we approved it. So in that sense, you're not directly competing with new applications. But if you come back to us and say, hey, look, we're going to have to change, this project that you funded for us isn't working out the way we thought it was. We're going to have to amend it. We're going to have to make some significant changes to it. And that's fine. You can apply for amendments like that. But the more amendments that you need to make, the more you're going to have to compete with new projects. So hopefully that makes sense. Charlie, you want to add anything to that?
I'm trying. Come on, camera. Well, if my camera will work. Anyway, yeah, I think one of the biggest pieces is, how well you're performing on the project currently to the basic plan. And then, like as Tony said, if things are not going the way you intended, don't wait until the renewal process to tell us. Reach out ahead of time. We may be able to help with some form of an amendment or something like that, or give you some advice on how to approach it, because we want to see all these programs be successful. But if we've got one program, if we got 2 like programs and both up for renewal, and one of them is really just hitting all the performance measures and exceeding them, and another one's still not quite got their plan together and not quite getting started and that kind of thing, then you can see we're going to probably prioritize the one that's actually getting things done. And there may be some hold on fundings or reduced fundings in next year's for those that haven't gotten stuff together.
Thank you, Charlie. The next question is, if 2 or more school districts within a Department of Behavioral Health Development Services region want to apply under a cooperative application, the locality where the intended fiscal agent district resides must be the primary applicant and not the school district itself, correct? That is correct. So school boards cannot apply for these grants, and they do not count as remember I said that the partnership has to include at least 2 cities or counties. And so when I say city or county, I'm talking about a city council, a board of supervisors. And so you have to have 2 school boards, or excuse me, 2 board of supervisors, 2 city councils, or a city council and a school and a board of supervisors in order to form up a cooperative partnership. So it has to be the county or the city that would be involved in that school district project. So as an example, if I'm just saying that because I'm right here in Richmond, if Richmond Public Schools and Henrico Public Schools want to partner together, then they would have to get Richmond City Council and Henrico County Board of Supervisors to be the partners on the project. So hopefully that clarifies the question.
And really, the school districts would be subrecipients of the grant from
Exactly.
through county and the city. That's the role. But we do have many grants where the subrecipients are kind of doing a lot of the administrative lifting for the city or county by putting together all the data for the applications and those types of things, and kind of driving the ship while there's oversight from the localities. And that's an okay model to work with too, if your city or county is okay with it.
The next question is, I work at a nonprofit. It's the Hazelden Betty Ford Foundation, working on the prevention and early intervention team. How could we apply to support Virginia with our evidence-based programs? So the OAA, the authority, does not endorse any nonprofits or for-profits or any other vendors because we make the funding decisions. So any organization that wants to work with a city or a county or a state agency needs to pursue that relationship directly with the city, the county, or the state agency. And once that relationship exists, then the city, the county, or the state agency can apply for a grant and talk about the benefit in their application. They would highlight the benefit that exists of working with that nonprofit or with that for-profit vendor. So again, because we don't give the award to the nonprofit, we give it to the city, the county, or the state agency that's acting as the fiscal agent. The next question is a training on ideas for use that do not create long-term funding need would be great. It's difficult to know what programs to start or fund, but specifically ones that won't require local funding after these funds are gone. I hear you. It's difficult to think of new programs that can be sustained without OAA funding in the future without creating an obligation on the local government. I hear you. Some examples that we've seen include one-time costs like construction of a facility. Other examples that we've seen is getting projects up and running that can then bill Medicaid. So an example of that is when cities or counties work with their community services boards to implement or expand office-based opioid treatment programs. Once those programs are up and running, they tend to be self-sustaining with Medicaid revenue. But I hear you, and we'll make a note to try to provide and highlight some other examples of projects that become sustainable on their own. Good comment. The next question is, what level of scrutiny is used for the pre-application review? Is it budgetary only or programmatic only? The question continues, we utilized this feature at the last cycle and an unallowable cost was inadvertently included and was not flagged by the reviewer. And that unallowable cost was later used as justification for the grant rejection. So this is one I'd want to look at in a little more detail because it doesn't ring a bell with me. When we review the application on a pre-application review, let me back up. For folks that don't know, we offer a pre-deadline review where we can look at your application and return it to you with any feedback or changes that you might need to make before the deadline. And we will continue to do that. It's our intention to provide the same level of review on the pre-deadline review that we will post-deadline review. Now, is it possible that we miss something? Absolutely, but our goal is to help you get these funds, not to reject them. And so for the person that made this comment, I'm making a note of your name, and we'll look into it, and I'll see if I can clarify or try to assist you in some way on that one.
Tony, if I could add there's a disclaimer that goes with the like pre-deadline review, which is we can review it all day and provide you all the feedback in the world. That review does not guarantee that the project is going to get funded. And some projects, may have maybe, and sometimes we don't do the full level of review at the pre-review that we do when we're actually working the application to decide about funding. We don't have that time and capacity. This is kind of a cursory look for big red flags, things like that, math that doesn't add up, things that we know are very obvious or unallowable. Some things are things like law enforcement costs may be allowable, may not. We may not have dug into something like that enough during the pre-review. Then we found it as we're doing the full review. So those things may change. And I believe I am familiar with this project, and one of the biggest reasons that it had to be rejected was it was just a cost issue as well on top of the unallowable item. However, as always, even with applications that we have to recommend denial for, that doesn't mean that's necessarily the end of the train. We're always happy to work with you and help you kind of refine that and come into an ask that might be more palatable for the grants committee during the next section. And I'm certainly working with some localities doing that now.
Yeah, and I guess Charlie's right, because what I failed to indicate in my response to this question is that, if we're doing a pre-deadline review of a grant that is in the competitive category, we can't make recommendations on the competitive grants until we've looked at all of them and compared them. So the review that we're giving you on a grant pre-deadline grant review is, does it appear to be complete? Are there red flags, like Charlie said? Is there information that might be helpful? But we're not telling you, yes, it's going to be funded. We're kind of doing an overall look at whether or not it's complete and includes allowable or non-allowable expenses. So I appreciate Charlie helping me clarify that. Okay, well, we're right at time, or a couple minutes over. Thank you, everybody, for attending. And if you have other questions that we weren't able to get to, my contact information is listed on the screen. Feel free to email. There's my cell phone number. Thank you again for your time, and we look forward to working with all of you in this upcoming cycle. Have a great day.